Good afternoon, ladies and gentlemen, and welcome to this webinar on the EU's General Data Protection Regulation and the requirements for DPIAs, or Data Protection Impact Assessments. I'm Alan Calder. I'm going to be your host this afternoon. I'm the founder of IT Governance, and we've been in the business of data protection for about as long as IT Governance has existed as a business. And with the emergence of the General Data Protection Regulation into the legal framework of the European Union in April of 2016, we became ever increasingly involved in the implementation process for it. We've produced books around General Data Protection Regulation. Our best-selling book right now is the Pocket Guide on EU GDPR, but the books that with Steve Watkins I wrote about data protection generally is now in its 6th edition, IT Governance, and there's a range of other books that I've produced. And over the 12 or 15 years that we've been in business as an organization, focusing on being a single source for books, tools, documentation, consultancy, training, and so on for anybody tackling governance, risk management, and compliance, we've developed a very comprehensive range of services, which means we inevitably talk to a very wide range of organizations about how they're tackling their general data protection regulation implementation challenges. Of course, the governance risk management world means that we're dealing with cyber resilience, information security, data protection, penetration testing, and all the elements which between them enable an organization to genuinely cope with operating in the cyber insecure world of the 21st century, where the penalties for failing to secure data can be quite so significant, both in terms of reputation damage, actual financial damage to organizations, and of course in the way of regulatory action. The agenda for today, we're going to have a brief look at the impacts of GDPR and the requirements around conducting a DPIA, what the benefits are for doing that. We'll look at the link between business benefits of DPIA and the GDPR's insistence on what it calls data protection by design, how a DPIA has to be approached where it's mandatory, and what the mandatory aspects of dealing with it are. Nevertheless, the benefits are much wider than just simply the circumstances under which it's mandatory, how that should fit into your risk management framework, and then of course the practical steps to conduct a DPIA. This is a maximum 40 or 45 minute webinar. I'm going to be talking to you, so I have to tell you now that at the end of this webinar you'll have an introduction to the idea. You'll not be an expert on how to conduct a DPIA. We'll be, as I said, aiming to finish the outbound part of the webinar in 45 minutes or so. We'll then be able to take questions. If you find you've got questions as I'm talking, please do use the questions function in the GoToWebinar panel, which is probably on the right-hand side of your screen. Type a question in there, and then when we get to the Q&A session, I'll turn to the questions. I'll read the questions out so everybody knows what the question was, and assuming that I can answer it, I'll then share with everybody the answer. All in all, it's about an hour that is committed to this, so the webinar will complete by 1600 hours British Summer Time. Yes, we will be circulating the slides to everybody who's registered on the webinar. Those typically will go out several days after the webinar. So let's get started on the impacts of the GDPR and how that links through to the requirements for data protection impact assessments. The reality is now that we're down to something less than 9 months to the point at which GDPR applies. It applies from the 25th of May 2018. It has been law. It entered into force on the 24th of May 2016. It is already law. We're over halfway through the transition period. On the 25th of May 2018, all entities that are processing personal data within the European Union need to be in compliance with the requirements of GDPR. That means that you need to have put in place prior to the 25th of May all of the changes that are necessary for you to be compliant by then. It's not the date after which you have to comply, it's the date by which you have to comply, and that's quite a significant issue. The regulation deals with the data rights of individuals, wherever they might be, irrespective, as the regulation says, of nationality or place of residence, and applies to entities that are based in the European Union or entities outside the European Union providing services to residents of the European Union. And the basic requirement is that those organizations that are within the scope have to put in place a management system to enable it to clearly demonstrate that it's doing what it needs to do to protect personal data and to have appropriate technical and organizational measures in place to ensure that it is appropriately protecting data. It's binding on all member states. The United Kingdom is a member state right up until the point at which it isn't. So GDPR applies in the United Kingdom irrespective of what the UK government does. The UK government has nevertheless said that the GDPR will apply and is putting in place measures to ensure that GDPR applies beyond Brexit as well. So from a practical point of view, GDPR is the way it's going to be inside the United Kingdom. You can download a copy of the regulation from the European Union's website. You see a link at the bottom of this screen. And it's important when thinking about who might have to do DPIAs to think about the material and territorial scope of GDPR. GDPR says that natural persons, that's living human beings, have rights to do with protecting their personal data, with how the processing is carried out, and also to unrestricted movement of personal data within the European Union. And the regulation applies to any personal data that is gathered electronically, digitally, or that is intended to be part of a filing system. So that captures basically anything other than perhaps a pile of visiting cards which you've left lying in a corner of the desk and you couldn't even begin to find your way around. That's not very structured as a filing system. So material scope, pretty well every form of personal data, analog, digital, in paper. If it's in a filing system, it's captured. If it's captured electronically, it's captured. If you're a controller or processor in the European Union, you have to comply. If you're outside the European Union, providing services into the European Union, you have to apply. So to a very real extent, GDPR is a global regulation, and the penalties for non-compliance are potentially significant. The supervisory authorities, of which there is at least one in every member state, are empowered from May 2018 to levy administrative fines, which, as the regulation says, have to be effective, proportionate, and dissuasive, taking account of the technical and organizational measures that the organization has implemented. And the tariff of fines allows for minor misdemeanors to be fined up to 10 million euros or 2% of global turnover, whichever is the higher. And major misdemeanors, those are the ones which are to do with breaches of data, data subject rights, breaches of the data processing principles, or breaches of the transborder data processing requirements. Those are the core areas of GDPR. Breaches there are able to attract fines up to 4% or 20 million euros. Bear in mind, this is the maximum, so fines are not likely to be at the maximum. Mitigating circumstances, the things that you've done to implement GDPR to meet the requirements to demonstrate accountability, all of those have to be taken into account in determining what kind of a fine is applied. A data protection impact assessment is described in Article 35 of GDPR. The benefit is set out there as being to help an organization identify, and at an early stage in creating a process or building a business or designing an activity, to address risks to the rights and freedoms of natural persons. So a DPIA is a process to identify and reduce privacy risks. It should be initiated and maintained throughout the development and implementation of a new project or a system. So if you're planning a GDPR project, you should right now be building into any IT or other projects that you have running a recognition of the need to meet data protection compliance requirements. If you build that into projects now, you're beginning to make important steps towards demonstrating data protection by design. And a DPIA is the overall process, which of course therefore is going to analyze how what you're planning to do with personal data will affect the privacy and the rights of the data subjects involved. So there's a legal obligation to commit to carry out a DPIA. There are also a number of very straightforward benefits, some of which of course are derived from the legal obligation. The first is transparency. And in an environment where consumers are increasingly concerned about how their data is used, transparency can be, for those organizations who address it right, a potential competitive advantage. Transparency to individuals that tell them how their information is being used. That also helps you make sure that how you're using information is going to be cost effective and sensible. The key requirements in the data processing principles are that data must be processed fairly, lawfully, and transparently. And in the second principle, that the data must be processed only insofar as it has to be processed to achieve a legitimate purpose. So purpose limitation and fair and lawful processing are the first two principles in the 6 data processing principles, and the transparency benefit that you get out of a DPIA also helps meet those data processing principles. Of course, transparency helps build trust, or should help build trust with data subjects, trust that you're looking after their data, you're only using it for the things that you should be using it for. The data subjects can rely on you only to use the data in a way that's expected. You won't sell it to a third party, you won't do something with it that's unexpected. And so that's important. Particularly important is the way, by applying the 6 data protection principle, which the DPIA would drive you to do, you can demonstrate the data is secure. And secure data, a DPIA should minimize the amount of data you collect, minimize the period of time for which you hold it, ensuring only that you have the data that you need to achieve the purposes for which you've collected it. Should enable you also to reduce the costs of the system, the costs of processing, holding, managing data, the costs of meeting data subject access requests. All of those are reduced as an operating expense if you've minimized the data that you're holding. And of course, a data protection impact assessment, if you're deploying it across the organization, will help build awareness inside the organization of what the GDPR obligations are, because all of the people involved in a project or involved in a particular process on which you're to which you're applying a DPIA will have to learn what it is. You'll build awareness, and so DPIAs are a useful part of the staff awareness activity that is a necessary component of your overall GDPR project. And therefore, a DPIA is giving board a number of things. The first, obviously, is it's enabling you to comply with your obligations across the 6 data processing principles, across the requirements under certain circumstances, which I'll touch on shortly, to carry out DPIAs. You're able to comply. You're able to demonstrate that you've not been negligent. You've been able to demonstrate that if there is a breach that you have to report, actually you had taken appropriate steps to minimize the impact on the data subject. So compliance is a significant benefit to the organization, and assurance both to the board and to individuals that you're complying with your obligation comes from, for instance, publishing the DPIA, albeit in a cut down form to protect the security measures which you've determined. So assurance to individuals that you've followed best practices inside your project is another way of building trust with customers and building long-term competitive position in a market where, certainly where the European Union is concerned, is going to prioritize and value much more highly those organizations who recognize and meet their data protection obligations. So there are good business reasons why you should be considering a DPIA. There are also legal reasons why you have to consider a DPIA, and I'm going to briefly look at where a DPIA is mandatory, and that's set out in Article 35 of the regulation. Article 35 says, first of all, that where the processing of data and Bear in mind that the GDPR's definition of processing is extremely wide. It covers the collection, the archiving, the looking at, the restructuring, the amending. Anything that you do with data, online or offline, is processing. And so a DPIA is required where that processing is likely to result in a high risk to the rights and freedoms of natural persons. So high risk, GDPR does not define what high risk is, but high risk is something, therefore, which out of your own risk assessment methodology, and GDPR says you need to have a risk assessment, you're able to determine as being high risk. So what is going to be a high risk, in particular where the processing is going to involve new technologies and the purpose of the processing, then a DPIA is mandatory. It's particularly required, and the GDPR then says a bit more specifically, where your process is an automated one. It includes profiling perhaps, and the outcome of the process will be decisions that have legal effects on the persons whose data you're processing. So automated processing and large-scale processing of special categories of data or of personal data relating to criminal convictions, mandatory DPIA there. And then finally, systematic monitoring of a publicly accessible area on a large scale. So if you're running CCTV cameras on a large scale is not defined, but certainly that's going to mean more than one or two, unless the one or two cameras are capturing millions of people. There's a number of relativities in it, and we expect to see emerging guidance and court cases over the course of the next few years which narrow down those definitions. But systematic monitoring of a publicly accessible area on a large scale mandates a DPIA. So Article 35 says specific circumstances and some general circumstances when a DPI is necessary. It also says that in order to make it easier to determine whether or not you need one, the supervisory authority in each member state should publish a list of the operations that in its opinion require a DPIA, and these lists will emerge. There's not much guidance yet, so you need to be paying attention, and you can't afford to wait. You can't afford to say, well, I'm not going to do anything until the supervisory authority publishes a list, because it's obvious to me that I'm processing data on a large scale in a public area. I need to get on with it. So don't wait for the supervisory authority to publish a list. If you think you fall within the range of processing activities which a DPIA is mandatory, get started now. You certainly should be seeking the advice of the data protection officer before you get going. The DPO has a mandatory role in providing advice on how DPIAs are carried out. And the DPIA as a minimum is going to produce a document which describes what the processing is taking place, what the purpose of the processing is. It'll set out what the legitimate interests of the controller are, and remember that the second principle requires that there be a legitimate reason for the processing of personal data. The necessity and proportionality of the processing should be assessed. The risks to the rights and freedoms of data subjects should be assessed, and particularly determining whether there is A, a risk, or B, a high risk is important. And then what you're going to do to address the risks. Codes of conduct, if they exist, you should be looking at which ones you can comply with. Any other safeguards and security measures, any other standards, national or international, that you can comply with in a way that will identifiably reduce risks to the rights and freedoms of natural persons. And then, of course, as this is about protecting the data of data subjects, the GDPR says, in effect, why not also talk to data subjects? It's a sensible thing to do, get their view on how you're protecting their data. Very good way of demonstrating transparency, demonstrating accountability. Talk to the data subjects about what you're planning to do, and then tell them how you're dealing with data. So not all projects will require the same level of analysis. There's a very comprehensive DPIA which you might need to be might need to be done might require, for a complex process, a number of people involved in doing the DPIA. It might also be that while there's a lot of data being processed, the number of steps in it is fairly straightforward. So it might be a much lighter touch DPIA, but the elements are the steps to what you're going to do are exactly the same, whether you're doing it on a big comprehensive process or in a relatively simple process, how you go about doing it. And we'll look at that shortly. So high risk to data subjects. That means that as an organization, you do need to determine what risk is. GDPR doesn't tell you. It doesn't give you a graph or anything else. It says you have to determine what a risk is, and you have to determine appropriate measures to reduce risk. So risk is defined. The most widely used international standard for risk management is ISO 31000. It defines risk as the effect of uncertainty on objectives. Mostly organizations translate that into something more measurable, something more easily capable of application. So it gets talked of as being a combination of the likelihood of something happening, and if it does happen, the impact on the organization. And that captures the two ideas: that a risk to be meaningful, for you to have to worry about it, A, it must be possible, it could happen, and B, it must have an impact if it could happen. So you should be able to, if you adopt that kind of definition, be able to eliminate all of the risks where, yeah, if it were to happen, it would have a big impact, but the chances of it happening are close to zero. So if you're in the Caribbean, clearly the chances of a major hurricane are high. The impact of a major hurricane is high. If you're storing data in the British Virgin Islands, you'd have to take into account the impact on the organization and on the rights and freedoms of data subjects of losing servers if they're inadequately protected. The risk of a hurricane in the eastern region of England is minimal. So planning to build a data center a mile underground in order to protect it from a hurricane would be a complete waste of money. There is actually no risk because there's no likelihood of the thing occurring. So defining a risk as being a combination of likelihood and impact is an important step in putting in place an intelligent approach to managing risks to the rights and freedoms of natural persons. And when we're talking about privacy risk, we're really talking about risk to both the organization and to the individual. Of course, we're talking primarily about risk to individuals. What happens to the individual if their data is corrupted, if somebody else is able to steal the data, if the data is not available for the purpose for which it's collected? All of those lead to impacts on the individual. The potential for damage or distress is obvious. There's also a risk to the organization. The risk to the organization comes with the loss of customers, the loss of reputation, and of course from the 25th of May next year, the possibility of data subject actions against the organization and the risk of regulatory action in the form of administrative fines. So privacy risk should already be on the corporate risk register. The impact on the organization should be on the corporate risk register. It's unlikely to be there now, but the risk to the rights and freedoms of data subjects should also be a specific area that the board addresses. There is a requirement in Article 5, Clause 2 of GDPR that the organization should be able to demonstrate it's accountable for managing risks to rights and freedoms. And the starting point for demonstrating accountability, of course, is the board having recognized that it's accountable and that it's kept that onto its corporate risk register. So privacy risk emerges in as a result of data which is inaccurate, insufficient, out of date. It means that communications will not reach people that are entitled to know that something's going on. They won't, at simple levels, have parcels delivered to them because you've got the wrong address. It means that important letters won't reach people, which could be information that's vital to them, could be financial information. It means that if the data is wrong, private information could be sent to someone who's not entitled to see it. If you keep information for too long, the failure to observe the limitation of data then the period of time during which it's exposed to attack by outsiders is increased. The same problem applies when you have accessible relevant information that could be stolen in a cyber breach. It's accessible to people who otherwise see data that they might be able to use they're not entitled to. Insecurely transmitted or stored data makes it very easily accessible to cyber criminals, and even more easily accessible to disgruntled members of staff or people who are working for, only applies of course some people, to foreign governments or to competitors, but who are inside your organization, perhaps posed as cleaners, and can address insecurities to access information. And all of those kind of risks mean the data can be used in ways that the data subject doesn't expect and which he or she would find unacceptable. So privacy risk, you need, if you're thinking about risks to rights and freedoms, to be thinking about not what are the consequences on the organization of keeping data for the next 20 years, but what are the consequences on the individual. What you're tasked with is managing risks to the rights and freedoms of the data subjects. And so you might consider doing a DPIA in any number of circumstances. So for instance, when you're consolidating information held in separate parts of the organization, you're putting two databases together, you're creating a single process out of 2 or 3 processes, a much better joined up process. Inevitably means that many people will get to see data that didn't otherwise see it. You'll be putting different pieces of data together that weren't previously combined, which might give better insights to your users around data subjects which aren't what the data subject expects. So databases that consolidate information would be an obvious candidate for a DPIA. If you're monitoring members of the public, which could be CCTV cameras, it could be electronic admission systems where you're collecting personally identifiable information, giving somebody an electronic card that enables them to get into a building or move around. That's monitoring members of the public potentially on a large scale. A new IT system for storing and accessing personal data, a new web system, obviously is a potential risk, potentially a high risk to rights and freedoms of data subject. If what you're planning to do with the data is something that the subject would think would be was not what they expected or might be intrusive, or of course, if you're going to share the data with a third party. All of those are typical areas where a DPIA you might think would be a sensible and appropriate thing to do. Having identified risks to rights and freedoms of data subjects, of course, you're going to take actions to address the risks. You're going to select controls and you're going to make changes in how you're planning to collect data. So you might determine that you're collecting more data than you need. You don't need to go about protecting the data better. You need to collect less data. So the logic of a DPIA is that you should be thinking about the application of the data processing principles all the way through the process, not just the security controls that you put in place. What you're looking to do is to reduce the risk to the rights and freedoms of natural persons to a level that's going to be acceptable to them, not to you, but to them. Because you might say, well, we can live with £25,000 or £250,000 worth of fine because the cost of dealing with it is much greater. Actually, the data subject who suffers identity theft, that might not be an acceptable risk at all. So you're looking at how do we reduce risk to a level that's acceptable to the data subjects. And of course, in giving you data subjects expecting you to do something with it. They know there's going to be some risks. They're just expecting the risks to be properly managed in a way that they're not exposed. Article 36, remember Article 35 sets out the mandatory requirements for DPIAs. Article 36 says that there are certain circumstances under which you must consult with the supervisory authority. And that's specifically where the processing that you're planning to carry out indicates the likelihood of there being a high risk to the rights and freedoms of data subjects. And under those circumstances, you have to carry out a DPIA and you need to consult the ICO in the UK. The ICO has to give you written advice on what to do, which is likely to mean he has a copy of our code of practice on how to do DPIAs. They might ask you for more information about what you're doing and how you're going to protect the data, about why it's necessary, what the purposes and means of processing are, how you're going to safeguard it, what measures and controls you're putting in place, who the data protection officer is. The assumption here is that you're doing a DPIA because it's mandatory, therefore it's likely also to be mandatory that you have a data protection officer. In any case, as we said elsewhere, most organizations should consider having a DPO because a DPO is a key role in providing unbiased advice to senior management on how to comply with the requirements of GDPR. ICO is entitled to see a copy of the data protection impact assessment and of course to get any other information they might need in order to assess what you've done. So DPIA is a key tool of GDPR compliance. It's also therefore a key part of an organization's risk management framework. Article 32 talks about how an organization can use its adherence to an approved code of conduct or certification mechanism. So ISO 27001, for instance, is a standard against which you can be certified, and you can use those as ways to demonstrate that you've put in place appropriate controls to meet your requirements to have relevant organizational and administrative measures to protect the rights and freedoms of data subjects. So information security, cybersecurity management systems like ISO 27001, business continuity systems like the international standard 22301, and a personal information management system, currently a British standard BS 10012, are standards that you could use to demonstrate you've taken appropriate steps to meet your compliance obligations. They don't, of course, prove that you're in compliance. GDPR is a law, and therefore ultimately compliance depends on legal decisions or appeal court decisions. All they can be used for is as best practice guidance on what to do and demonstration that you've applied best practice. In other words, you've been seriously non-negligent in approaching the requirements to manage risks to rights and freedoms. Article 32 says the controller and the processor have to really cooperate to make sure that appropriate measures are in place to protect rights and freedoms that should be appropriate to the risk. And it does, of course, define very clearly the risk is virtually anything that might undermine the confidentiality, integrity, or availability of the data, whether in flight or at rest. So access to personal data transmitted, stored, or otherwise processed. So the very wide-ranging definition of processing, the very wide-ranging definition of data means that you need to take those into account and then consider the risks, the rights and freedoms. Considering all of that, and recognizing that there'll be different likelihoods and different severities, and on that basis put in place appropriate technical and organizational measures to ensure that processing is performed in accordance with the regulation. So the DPO has got a key role to link what the corporate risk management approach is doing with what the DPIA and GDPR requirements are, and to make sure that risks to personal data are effectively managed. So how do we go about conducting a DPIA? What are the steps for it? The steps are relatively straightforward at a high level. So let me just briefly talk you through those. The first step is to identify that you need one. And you identify the need for a DPIA by assessing the process. Are we processing a high volume of personal data? If we are, is there likely to be a risk to the rights and freedoms of data subjects? And I would work on the basis that if you're processing high volumes of personal data, there's likely to be at the least a risk to the rights and freedoms, if not a high risk. You can't determine whether or not there's a high risk usually without doing a DPIA. So high volumes of data subjects, do a DPIA. That'll tell you whether there is the kind of risk about which you need to do something. If you decide that there's probably not a high risk and reality demonstrates that there is, the absence of DPIA is likely to be used against you. So you ask screening questions at the beginning of the creation of a process or of a project. What personal data are we gathering? What are we going to do with it? All of those kinds of things enable you to identify that there is a need for the DPIA to be carried out. If there is, and frankly, particularly if you're an agile project development organization, process development, you want those kinds of question asking skills to be embedded in the organization so that everybody involved in creating a new process, a new piece of software will know that the questions that need to be asked are all around the 6 data processing principles to determine whether or not a DPIA is necessary. The second step is to describe the information flow. What personal data are we actually gathering? What are we doing with it? How are we using it? Where it's going to? So if, for instance, you were designing a recruitment process, you might say, where do we get information from about people who want to come and work for us? We have individuals sending in their CVs. That's one data source. We have recruitment companies sending CVs. We might have headhunters that we specifically tasked with finding us people. We might also be finding information on LinkedIn, for instance. So you have 4 or 5 different sources of information. It's coming to you potentially in different formats, probably mostly digital, maybe some of it in paper format. Who does it go to? Who's receiving the data? Where is it being stored? How are you protecting it? At the point that you decide to offer somebody a role, what happens to the recruitment data? At the point you decide not to offer somebody a role, what do you do with the data? How do you identify the lawful basis of processing? How long should you keep the data for? Those are all the questions that you're asking as you describe the information flow to make sure that you've properly understood how the data is being used all the way through the cycle up to the point at which the data is deleted. The third step then is to think about the risks. Now that you know where the data is coming from, who's got access to it, what assets it's being processed through, how it's being used, you're in a position to think about what the risks might be at each of those stages. And the risks are going to be different at each of the stages. And the risks are not just the risks that somebody might be able to access or compromise the data, but the risks also include the possibility that you might be transgressing a legal requirement. So, for instance, you might rely on consent as the basis on which you process the personal data of people who are applying for a job with you. That's a perfectly logical, rational, lawful basis. However, at the point when you decide to offer them a job, you're going to be processing their data as part of your employment process, and consent is not an appropriate basis then, because the consent can't be given equally. The requirement for consent is that it should be something which the data subject can give without fear of suffering. In other words, the relationship between data subject and controller has to be an equal one, and the determination by the supervisory authorities around Europe is mostly that employers are in an unequal relationship with employees. So you need a different lawful basis of processing, and the identification of privacy and related risks can only be done properly if you've identified how data is being dealt with at each of the stages in the process. So identify risks. The next step is to identify what you're going to do about them. So determining likelihood and impact of an identified risk occurring, then you can determine how you're going to deal with it. And dealing with it might be as simple as saying, well, in that case, we won't collect the data, or in that case, we won't store the data, or in that case, we'll delete the data at this point. There might be simple changes you can make in the process. You might also make a determination to put additional technical administrative controls in place to ensure that the data is properly protected. So you might say, well, we're going to encrypt all email, we're going to encrypt the database, because that way we protect the special categories of data. So identify and evaluate appropriate privacy solutions, make sure they're going to be capable of doing what you need them to do, put them in place, and then sign off on the DPIA. Yes, we've done what we needed to do. We've identified what the outcomes are, check the overall process, the only thing we've missed. Step 5, record the conclusions, document then the outcomes and build them into your project plan. Think about a DPIA, which is something which needs to be in a software development environment, an agile software development environment. The DPIA itself needs to be agile. It needs to be something you can do quickly and easily. So you need mechanisms and skills in the project team, which enables you to go through the cycle as part of creating each sprint to make sure that you've built data protection into the project itself. So integrate the outcomes of your DPIA into the project plan, and then of course make sure that what you plan to do works. Monitor the effectiveness of the decisions that you made in the project, in the software, in the system, make sure it's working as you want it to, and of course also look at the way in which you can improve the process. your DPIA the first 2 or 3, 4 times you do DPIAs. It won't go perfectly as you develop the skills and competence in-house. Continue reviewing how well your DPIA process actually works so that you can drive improvements. And over time, it should become a compliance tool inside the organization which drives the kind of benefits that we were looking at the beginning of this webinar in terms of customer trust, in terms of cost reduction, in terms of efficiency and effectiveness of process, because you've got only the right amount of data in the process, you know where it is, you've got it protected, and you've dealt with the long run possibility of significant breaches which occasion all of the cost disruption and damage that breaches cause for organizations right now. So 7 practical steps to conduct a DPIA. Consult with stakeholders as you need to. The data subjects, it's their data. Particularly important if you're designing a big data application to think of ways of consulting with data subjects for whom otherwise the big data application might seem to be particularly opaque. In IT governance, there are a number of tools that are available that you can use for doing DPIAs. There is a description in the implementation manual of how to carry out a DPIA. Pocket guides are a useful tool for informing people. The documentation toolkit contains a set of documents which also cover off how to deal with DPIAs, and the compliance gap assessment tool contains a high-level process assessment, what you might think of as a mini gap analysis tool, a mini DPIA tool. It's not really, because it doesn't look at all of the steps in a data flow, but enables you to look for an identified process at where the significant gaps in compliance might be. More importantly, there are a range of training courses, the most useful of which is likely to be the Data Protection Impact Assessment course, which is quite practical. We deliver this as an in-house course as well, where organizations want to do a workshop with a number of their staff that focuses on a particular process and leaves them with the skill to be able to take that on and do it themselves. So as well as foundation and practitioner training, very practical practitioner-oriented training is particularly the Data Protection Impact Assessment workshop. And then there is a wide range of consultancy offerings, from gap analysis through data flow audits, data protection officer as a service for organizations who don't want the expense of appointing a full-time DPO, help implementing personal information, information security management systems, cyber health checks, a whole range of the kinds of services that you might expect from an organization like IT Governance, which specializes in providing a one-stop shop offering for organizations tackling their GDPR compliance challenges, which brings me to the end of the prepared outbound part of this webinar. There's now some 15 minutes available for questions and answers, and if you haven't already, the questions function in GoToWebinar is the best place to type your questions. What I'm going to do is I'm going to go through the questions that there are. I'm going to read out questions starting obviously at the beginning, so everyone knows what the question is, and then assuming I know the answer, I'll share with you the answer. So the first question: what is the situation around companies being required to hold customer data under other laws beside the GDPR? The lawful basis of processing is set out in Article 5 of GDPR, and it recognizes that while, for instance, consent, the requirement to process the data in order to meet a contractual requirement with a data subject on a lawful basis, so is a statutory requirement to process data also a lawful basis. So if there is a legal requirement placed on you by a government to collect data for a particular purpose, that's a lawful basis of processing. The fact that you have to collect the data doesn't absolve you of the need to carry out a DPIA if the data you're capturing falls within the definition of the areas for which a DPIA is mandatory. So GDPR is only applicable to personal data, but what about IP or company data? It's a data protection impact assessment is specifically designed and specifically mandated for assessing impacts on the rights and freedoms of data subjects, but the methodology can equally well be used for corporate IP, for other confidential information of the organization, because the DPIA essentially draws on well-established risk management principles and processes. So yes, a DPIA is designed for risks to personal data, but the methodology can be used much more widely. Before we start our GDPR program, should we carry out a DPIA? No, you should carry out a DPIA as part of your GDPR program. Your GDPR program should start with accountability, with getting GDPR onto the board agenda, making sure that there is clarity about roles and responsibilities, proper budget allocation, identify the high-risk data flows, and then concentrate on doing a DPIA where you have highest risk. In the time which remains, you probably don't have time to do a DPIA on every process, so you want to focus on those where the highest risk is, and you have a number of other areas you need to be addressing at the same time. I work for a medium-sized MSP with our own data center. Our clients keep their customer data on our servers. Who has to produce the DPIA? So that's a good question. GDPR says that it's the controller who determines the means and purposes of processing, who's responsible for ensuring that a DPIA is carried out, and that any third-party processors with whom they contract for any part of the processing of that data should, where necessary, contribute to the DPIA. So in simple terms, your customer or customers are responsible, if their processing falls within the categories that mandates a DPIA, or if they're just simply being sensible, for carrying one out. You, of course, as a data center, should have a very clear contract that sets out your obligations in terms of the processing you do, which will essentially be, I suspect, archiving or perhaps providing a hosting environment, whatever it is, and which tells you how to respond and what to do if there's a breach, sets out your obligations, because GDPR says it's illegal for a processor to process any data other than under the terms of a contract with a controller. So the controller has to do the DPIA. You have to comply with the findings of that or contributes to it under your general obligation to help the controller meet its obligations. We only process fleet car business decision makers and their contact details, but in potentially large volumes. Do we need to conduct DPIAs? So I suspect that you might be processing locational data. You might be processing potentially biometric data. There's a number of ranges of data which would place you in the processing special categories of data. You might be processing information about journeys. There's a whole number of questions which I'd need to know more about before I can tell you whether you have a mandatory DPIA. The fact that you're processing large volumes of data almost certainly indicates that a DPIA is probably mandatory. I know probably mandatory sounds silly. I would say if you're processing large volumes of data, do a DPIA. What is deemed high risk to the rights and freedoms of the data subject is a very sensible question. GDPR does not tell you what high risk is. That means you have to work it out for yourself. Your risk assessment methodology, and GDPR says you have to have one, has to have some form of risk scale which looks at what high risk might be. And one way of determining high risk is to ask yourself what would be a real problem for you as the data subject. So I would suggest that anything which would involve identity theft would be a high risk. Anything that would involve access to personal data, personal records, bank information, information about any special categories of data, anything like that I would describe as high risk. If you're processing wide volumes of data, I would say, lots and lots of different types of data about the same individuals, I'd say probably high risk, because somebody breaches it, they can get hold of a lot of information. So high risk is going to be about volumes of individual data and the volumes of information about individual data subjects. Some mixture of those are going to help you determine what high risk looks like. I've contacted the ICO about advice on a DPIA for health data. They stated they can't advise, and it's our choice as a controller. Well, the ICO is supposed to publish a list. We're waiting for them to do it on what the mandatory DPIA, mandatory processes for DPIAs are. I would say that if you're processing large volumes of health data, you should do a DPIA. If you're in the health sector, if you're a hospital or a pharmacy, or any one of those where you're processing what's undoubtedly going to be a special category of data, then, and you're doing it in any volume, I would suggest you think about doing a DPIA. I need to know more, obviously, about what you're really doing to give you proper advice. It's not really your choice as a controller. The obligation is on you as a controller if you fall within the requirements of Article 35 to carry out a DPIA. It's not a do I feel like it, don't I feel like it. It's a do I have an obligation or don't I question. How do you calculate the time needed for a DPIA? It depends on how many people are involved in the process and how well documented the process is. So if you've got a process which is well documented, you know already exactly what happens with all of the data that carries inside it. You know what types of data it is. The people who are involved in the processing understand what they're doing. You could do a useful DPIA in a business day. If it's a very substantial and complicated process, a DPIA could take you between 3 and 5 days, but it's that kind of range of quantums depending on volume of data and complexity of processing. Is there a definition of high volume of data processing? Again, no. There is guidance which suggests that high is measurable in one of two ways. The first is in absolute numbers. So you're processing thousands or tens of thousands of data subjects data, that's going to be a high volume. But on the other hand, if, say, you're processing the data of 500 out of 600 members of parliament, in that context, 500 members' data would be high volume. So there's either a contextual or an absolute aspect to it. Until we've got several court cases out of the way that give much better guidance on what high volumes and high risk looks like, we're advising all of our clients to err on the cautious side of your judgments. Is a DPIA required for existing processes and systems? The GDPR requires that you are compliant with its requirements on the 25th of May. It doesn't say do a DPIA afterwards. It says where a process involves processing data where there's a high risk, you have to do a DPIA. So the simple answer is if you're doing that now, do a DPIA now, so that by the time you get to the 25th of May, you're already implementing the findings of your assessment of data. We're sending out the links to those of you who didn't see a particular slide. Will be able to see it when you get the slides. What's our opinion regarding the use of ISO 27005 instead of ISO 31000? It's perfectly fine. What you're looking for is a recognized method of assessing risk to data. ISO 27005, ISO 31000, and there are other standards. They're all perfectly legitimate. NIST has published in the US standards for risk assessment. The only key thing you've got to do is remember that all of those standards are looking at basically risks to assets and to the organization that owns the asset. What you're looking for is to deploy that mechanism or that methodology to assess risks to the rights and freedoms of data subjects. And so the focus of the risk is very different, even though the methodology will be exactly the same. Does GDPR include supplier and customer information? Not specifically, but the key thing is GDPR does not differentiate between personal data that is collected in a business context from personal data that's collected from consumers. So Alan Calder at itgovernance.com is as much personal information as is Alan Calder at gmail.com. Neither of those, by the way, are actually email addresses of mine, but they are both, from a GDPR perspective, personal data. And that means that information you collect about customers or contacts at customers, information you collect about contacts at suppliers, all of that is personal information, and you need to apply the same levels of protection to it. You might determine that the possibility of there being a high risk to rights and freedoms where all you've got are business contact details is not that great, but it's nevertheless is personal data. You can't exclude it from scope. Do we know of any sources for completed DPIA, which is a good example of how they should be done? You won't like me saying this. Yes, we do. They all tend to be in our DPIA workshops. that's probably the only practical place at the moment, I'm afraid. Any main big differences between the Data Protection Act and the GDPR that we can think of, especially relating to personally identifiable information? The differences are huge. The Data Protection Act is a relatively simple act in comparison to GDPR. While some organizations think that the only differences with GDPR are the fact that the fines are much more significant and that there are 2 new rights to data subjects, the reality is that starting with definitions, it's very significantly different. GDPR has very wide-ranging, very detailed definitions of what personal data is, of what a controller is, of what a processor is, what a data breach looks like, very specific requirements that there are contracts in place between controllers and processors, that processors only process if they have a contract in line with the contract. All of that is a significant difference from DPA. If you think you're DPA compliant, which is not the case for most organizations in the UK, the journey to GDPR compliance is still a very substantial and significant one. I see there are 2 courses and one is a requirement for the other. Is there a course that covers both in one? Yes, you can sign up. There's a special price for doing the foundation and practitioner as a 5-day course. The reason for that is the foundation covers off core definitions and concepts that are not then dealt with in the next 4 days. So if you take that as a 5-day training course, what you get is a straight through program which enables you to come away from with a very solid understanding of what you need to do to address GDPR compliance inside the organization. HR data and legitimate interest. How about if you're a public body, or would you rely on execution of a contract? Well, the rules are slightly different for public bodies. It depends on whether you're carrying out processing in relation to a public interest task which has been given to you, in which case that of itself is a lawful basis for processing. But that's not necessarily going to apply to HR data. All HR data is almost certainly going to be processed in order for you to fulfill as an employer the contract of employment you have with the employee. Other than that data, and you have to be granular in your identification of lawful basis, other than that data which you're gathering to meet other legal requirements like evidence that you've collected national insurance and tax contributions, there's a different lawful basis for processing that. What about GDPR and database related to AML and anti-terrorism financing? Well, GDPR applies to that database. You have a lawful basis for collecting the data. You have to collect it in order to meet your obligations to screen people against anti-money laundering requirements, against anti-terrorism requirements. So you have to collect the data, but you have to protect the data. You can only keep the data for as long as you're required to keep it in order to meet those legal requirements. Meeting those requirements is your legal basis for processing the data, but you have to protect it. You can't say, well, I collected it and I didn't keep it securely. The fact that you didn't keep it securely will land you in a fine. What is the difference between light touch DPIA and full DPIA? It's really a bit of a misleading statement. A light DPIA really is the DPIA you do on a fairly low level process. A full DPIA is really what you're doing in most cases. Is GDPR only applicable for European Union, UK regions? The UK, of course, is part of the European Union at the moment. It applies to any entity based in the European Union processing data, irrespective of where that data subject lives. So the data subject can live in Korea or Australia, and they get the same protections as somebody who lives in France or the UK. It also applies to controllers and processors based outside of the European Union. So if you're an organization in, say, India that is processing data on behalf of a UK organization, you have to comply with GDPR. The UK organization has to itself comply with specific requirements before it can transfer the data to the organization in India. Is DPIA only required? We're coming to the end. There's only going to be a few more questions, I'm afraid. Only required for new processing after May 2018? No, you need to do a DPIA for every process where it is mandated, and you need to have done one by the 25th of May 2018. That's the be compliant on date, not the compliant after date. Are there any exclusions for registered charities? While there are a number of derogations in GDPR, I see nothing which says that registered charities are off the hook. I see nothing in the behavior of the Information Commissioner which suggests that she takes it easy on registered charities. I think, therefore, that if charities are processing, I would just look, frankly, initially at where it's mandated. High volumes of personal data, where you're putting systems together that will create a high risk to the rights and freedoms of data subjects, or you're processing high volumes of special categories of data. If you have to do a DPIA and you're a charity, you've got to do a DPIA. I work for a trade association representing a specific sector. Is it possible, feasible, and/or logical to create? It's perfectly logical to create sector-specific DPIAs. Yes, can be very cost-effective to do that. What happens to companies that are not GDPR compliant after May the 25th? Well, the reality is most companies are not going to be compliant because in many instances, it's not clear what compliance is. There are a number of terms that aren't yet defined. There are a number of ways in which you have to comply that depend on court decisions. But really what happens is that if you are found to be non-compliant, you face administrative penalties of up to 2% or 4% of global turnover, depending on revenue. You can only be found to be non-compliant if one of three things happens. The first is the data subject brings an action against you, which they're entitled to do. The second is if you have a data breach, which you're likely to have, you have to report it to the Information Commissioner within 72 hours. Either of the first two things could lead to an investigation. And the third possibility is that the ICO chooses to investigate. Any one of those can lead to it being discovered that you are not compliant and haven't been compliant for a while, and the fine will be based on the extent of your negligence. When looking at supplier, I see no reason why you can't ask for a copy of the DPIA. If in fact you're the controller, you should be informing their DPIA because you are the organization that has the legal accountability or the legal responsibility for determining the means and purpose of processing. And I think we're hitting 4 o'clock, so we've got time really just for another 2 questions, and then I'll close up. If we are collecting corporate email ID of individuals, yes, that's personal data is the simple answer to that one. Our consultancy companies have provided DPIA accountable for a false positive evaluation. No, all a consultant company is doing is providing advice to you. If the advice they give you is bad, you're perfectly entitled to sue them for bad advice or negligence, but that won't absolve you from your primary obligation to comply with the General Data Protection Regulation. Ladies and gentlemen, I'm afraid that means we're closed up. Quite a lot of the questions that I've asked are repetitions of some of the previous ones we've answered. We will try and get all of these additional questions answered and the answers added to the list of FAQs which we publish on a regular basis. And I would therefore just like to say thank you to, yes, there are templates for DPIAs, there are DPIA tools. If you have a look at our GDPR GDPR toolkit, there's a DPI tool in there. Ladies and gentlemen, thank you very much for being here. I wish you luck with your GDPR compliance project. There are additional webinars being run, both first step webinars and webinars dealing with specific subjects over the course of the next few months. Please do, if we can help you on your GDPR compliance journey, and it's a journey, not a destination, please do come back to itgovernance.co.uk. Thank you for being with us this afternoon.